Let's start. Good afternoon, everybody. Today is Thursday, October 24th of 2024. We are convening a session of the Philadelphia Tax Review Board. With me today is our chair, Paula Weiss, as well as board members John O'Connor, George Matthews, and Nancy Cameradiner. My name is Melissa Andre. I'm the executive director, and I am responsible to let everybody know to please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy. And by continuing to be in this meeting, you are consenting to being recorded. This recording will be posted on the Tax Review Board's website. At this time, I'm going to transfer control to our chair, Paula, and I'm also going to run and put in case number 2 in the room.
All right. Good afternoon, everyone. My name is Paula Weiss, Chair of the Tax Review Board. Hearings for October 24th, 2024 are now in session. We are going to go in order on our docket based on who is actually in the room waiting to be heard. And our first case is going to be case number 2, 613 North 44th Street. Last 4 digits of the docket, 9135. And we're going to wait for Ms. Campbell.
Hello again. I'm in this square now. Ms. Campbell has informed me that her attorney, Mr. Quinn, is not here yet. And so she's okay with us moving to the next case. That case will be cases 4 and 6, Glory Baptist Church.
All right, we're going to move on.
I actually do have an update for this that I don't know that an attorney is necessary. After the city reviewed the bills, we do believe that they were issued in
Hold
error.
on a second. Hold on, Ms. Reiner. Let's get Ms. Campbell in the room then, if there's some information that the law department wants to provide. So let's.
Ms. Campbell? Why don't you have a seat, and then the board will explain it to you, okay? Well, maybe perhaps just listen to what the board has to say, and then if you still don't feel comfortable with that, we can wait for him, okay? Okay. So just have a seat.
All right, Ms. Campbell, good afternoon. Have a seat. My name is Paula Weiss, Chair of the Tax Review Board.
Okay.
Where is she? Okay. I know you want to wait for your lawyer, and that's perfectly fine. However, as we're getting started, the city's attorney would like to just provide us with some information. So I want you to hear it, and then we can certainly still wait for your attorney if you choose to do that. We're not going to ask you to go ahead without him, okay?
Okay.
Okay. Could you just state your name for the record, please?
Irma Campbell.
Okay, thank you. All right, Ms. Reinhardt.
Thank you. And good afternoon, board. Michelle Reinhardt for the city of Philadelphia. After reviewing Ms. Campbell's petition, we agree that these bills were issued in error. And as a result, I have already made the request for them to be removed. My understanding is that it will take a couple days in order to be successfully completed. However, that request has already been made previously before today. And my understanding is that it is in the process.
Okay, so Ms. Campbell, as Ms. Reinhardt is explaining to you, the bills that you're challenging are going to be removed. The city's agreeing with you. They should not have been issued to you, and they're taking them off.
Yeah.
Okay, so do you still want to wait for Mr. Quinn, or are you satisfied that everything has been resolved?
No, I'll wait for him still.
You still want to wait for him? Okay.
Okay.
That's perfectly fine. You can go out into our waiting room, have a seat.
Okay, thank you. Because I'm trying to call him.
All right, so we will move on then to cases 4 and 6, which are Glory Baptist Church. Last 4 digits of the docket, AGCV and 2JCV. For cases 4 and 6, and it's 4130-42 Aspen Street.
Thank you so much. Just have a seat. Okay, thank you. Keep your voice nice and loud. I will, thank you.
Good afternoon, ma'am. My name is Paula Weiss, Chair of the Tax Review Board. Could you state your name for the record, please?
Yes, Bernice Taylor.
Okay, Ms. Taylor, what is your relationship to Glory Baptist Church?
I am a
member and am here today as a party on their behalf to provide information about their view on the appeal that we submitted.
Okay, do you swear or affirm the testimony you're going to give in these matters will be the truth?
I do.
Thank you. All right, we're going to turn to the city first to get the dollars in controversy and the years in question, and then we'll come back to you for you to explain to the board why you're here and what you're looking for from the board.
Thank
Ms.
you.
Reinhardt, who do you have testifying today?
My understanding is that Ms. Mitchell for the city will provide the numbers.
Okay, good afternoon, Ms. Mitchell.
Good afternoon. How are you?
Good. Could you state your name and position with the city, please?
Sure. My name is Lashika Mitchell, and I am a code administrator.
Do you swear or affirm testimony you're about to give in these cases will be the truth?
Yes.
Thank you very much. All right, so we have two petitions under consideration. Could you give us the numbers for, I guess, both of them? Case number 4, case number 6, demolition and nuisance?
Sure. 4130-42 Aspen Street. Bill date 4/10/2024. Bill number 2024-001691. Principal amount $48,088 even. Admin charge $10,266.48. Interest $887.31, for a total of $60,041.79.
Okay.
Second entry, once again, 4130-42 Aspen Street. Bill date 5/23/2024. Bill number 2024-003036. Principal amount $11,882.50. Admin charge $2,495.33. Interest $287.56, for a total of $14,665.39.
Thank you. Ms.
You're welcome.
Reinhardt, thank you. Any opening comments?
Just as a very brief opening statement, this was an unsafe building which was demolished following issuance of notice of violation. The building was operating as a church, which is my understanding. At the time that the notice of violation was issued, following consideration by the church of that notice, they provided a notarized letter indicating that they wanted to resolve the violations as quickly as possible. And in order to do so, requested that the city demolish the property. These bills are a result of that request.
Okay. All right, Ms. Taylor, what would you like to tell us about this matter?
I would say that what Ms. Reinhardt has stated thus far is accurate. We understood the seriousness of it, and since we did not have the funds, after we met, we immediately contacted the initial inspector, Mr. Madras, on February 13th, explained to him the circumstances and said that we did not want to ignore this because we understood it was a very serious matter, but were without adequate funds to demolish it on our own, as well as knowledge to understand all you have to do is to do it properly if you have the funds. So he recommended that I contact Mr. Robakowski, which I did, and on that same date, February 13th, he spoke with me extensively, talking about the process after I explained to him the dilemma we were in and our desire to act quickly as we could to get this done, that there was an option to have the city to demolish it. And so, yes, we did agree to have that happen. And I very much appreciated the assistance from Mr. Madras as well as from Mr. Robakowski, and the forefront that they explained things to us to help us to get this done.
Okay, so what brings you here today?
Okay, we were appealing because one of the things that we were advised is that we would have the ability to appeal once the bill came to us, which is what we did. And initially, our appeal was, the first appeal, yes, the first appeal is like, the first appeal was for the demolition. And we were concerned that when we got the bill, it did not have an itemization of the charges to help us to understand fully how it arrived at the total amount. We made a request to many people and finally got to L&I, and we were told that there's a rights to know division and that I should send correspondence to Tia Platt, which I did. I asked her in that for an itemization. She sent to me basically the notice to proceed and the purchase order. And as I looked at each of those, it did not provide an itemization of the cost. And this gave us concern. I would like to say again, we're not trying to evade and not pay, but we're trying to get the funds together, and we need to make sure that as we're doing so, that what we're paying for is what we think we properly should be paying. And without an itemization, it poses some challenges because you really don't know what the costs are for different things. So you can say, well, is that one reasonable? Is that not reasonable? And so that was the biggest concern we had. So having received the information, and since it did not provide an itemization, we still were in a difficult position in looking at this. So, you know, our appeal had already been filed, and so we continued with it. Now, as we looked at it, you know, I really respectfully don't know why the bills are not itemized. I understand that they took the lowest responsive bidder, and I don't disagree with that. But I think itemization is important from the public perspective, particularly for us to really understand what we were paying for, and not that we can necessarily say everything is or is not reasonable, but you want to have a sense of it as to what the various items cost. And so we still are concerned that we've not been able to get that. I'm beginning to think that it's something that the city does not have, but it's curious to us that the bidder would not have that information available, could not have, you know, provided that if it were requested, because they had to have some way to arrive at the amount of the bid.
Okay, so that's the demolition specifically, and the second bill?
The second bill, similarly, we had a similar kind of concern. There were two levels of concern for the second bill, which dealt with the asbestos report and inspection. When we first received the information from Ms. Tia Platt for the demolition, she also included a statement that said that the asbestos could not be done. And then probably about 30 days later, we received the second bill. And so we were perplexed by that. Now, I must say, in all forthrightness, that I have had conversations with Ms. Reinhardt, and she's been very helpful in trying to provide more information. And even up until today, this morning, she was emailing me information as I was arriving here on the train, that I looked at some, and it has helped to explain some of the problems we were having. The major problem is that we couldn't understand how we got a bill dated, I think it was dated May 23rd, which said that the project was completed May the 10th of 2024, when the property was actually demolished in March of 2024.
Okay, but has that been resolved for you?
I think now we understand that much better.
Okay, so are you still questioning that second bill?
We don't have, I haven't had a chance to review everything, and I did talk to the members beforehand and asked them to think about it, and they are feeling, as I am, that we are, although we are still concerned, I'd say that from the information we've had, we feel much more confident than we did previously.
Well, Ms. Taylor, you're gonna have to provide us with, if in fact you want to proceed, you need to, with that specifically, now that you're telling us you got the information from Ms. Reinhardt, you would need to provide us with evidence and information to show the bill to be unreasonable.
Right. Well, again, that's something that I would not be able to do today respectfully, because honestly, I just received it this morning, probably about 12:30 is when I got that. And I quickly began reading it, sent some over to the other members. So I am not able to really say that. What I would ask of the board is if you could look at maybe some of the administrative charges, some of like the interest fees we've been charged, to assist us with that, because we have.
Well, we cannot do a half, we're not gonna do a half decision. If you want to proceed, we can proceed. If you want time for your board members to look at the information, then we can give you time to look at the information.
Well, no, we would like to proceed as I was suggesting. I did talk with them briefly, and right before I came out, I was trying to, get back to them again, because I was sending them information, and I don't want to belabor this, but I'm using the phone to send them information. It's not the easiest tool, and I know they have a printer, and I was hoping that they were able to see one document, but they hadn't been able to see the other. But I've explained to them what it was, and had said to them that I thought, and they were inclined to agree, that we were more satisfied than we were previously when we first started this. And that's why I was asking whether there was something else that could be done with the administrative fee or with some of the interest charges, because we were willing to try to, now I will just share this. I had even contacted initially the Division of Revenue and Taxes to talk with them about to start the arrangement for making some payments. And I was advised that if I did that, my appeal would be null and void. And
All right, so let's hold on then and turn to the city. Ms. Reinhardt, what light can you shed? I guess first let's start with the demolition bill, and then we'll move on to the second bill. Starting with, let's start with her primary concern, which is there an itemized billing from the demolition company?
There is not. We have the bidding documentation of the contract process, and Supervising Inspector Rybakowski is here in order to testify regarding the requirements of that process, how it is that someone becomes qualified in order to even make a bid in the first place, the costs that are associated with that, and the requirements under city code.
Okay, I don't think that Ms. Taylor is questioning the demolition itself or the process leading up to the demolition. So we don't need to, I don't think, have Mr. Rybakowski go from the very beginning, notices a violation and the findings that the building was imminently dangerous. I don't think anybody seems to be questioning that, but perhaps he can run through the bidding process, the various charges to the, or process for the contractors that would result in the end bill. And it would be nice if there was an itemization so that we would know what we were being charged, but there you go.
May I start by doing a very brief summary of the notice of violation and some photographs, just so that the board is familiar with the concerns of the property and what it looked like?
Very briefly, because doesn't seem to be part of the challenge today.
Okay. If I may call Supervising Inspector Rybakowski at this time.
Sure. Good afternoon, Mr. Rybakowski. Would you state your name and position with the city, please?
Thomas Rybakowski, City of Philadelphia, License and Inspections. I'm a construction compliance supervisor assigned to Contractual Services Unit or Emergency Response.
And do you swear or affirm the testimony you're about to give this afternoon will be the truth?
Yes.
Thank you. Ms. Reinhardt?
Thank you. May I please share my screen?
Yes.
Thank you. I'm sharing first what has been previously marked City Exhibit 1. Supervising Inspector Rybakowski, are you able to view this?
Yes.
This is a notice of violation in order to correct unsafe conditions dated February 3rd, 2024. Can you tell us just very quickly what the concerns were for this property?
The violation was issued an unsafe declaration for the main roof partially collapsed and also issues with the parapet wall.
Are there additional concerns noted on the second page?
There were violations issued in respect to a chimney concern with loose and missing bricks, and also that was notated, and there was a assertion for an engineer to provide a means and method on repairing the property.
And was there also a rear wall that was fractured with a tree growing through it?
That is also notated as well.
Moving briefly to City Exhibit 5, is this a photograph of the tree growing through the wall?
It would be, yes, it's upside down, but yes, there is a tree growing from the exterior wall of the property.
And City Exhibit 6?
This would be the concern of the main roof, illustrating the unsafe condition.
City Exhibit 7?
Another vantage point of the unsafe condition.
In the collapse?
Yes.
Is City Exhibit 8 yet another photograph of the partial collapse?
Of the main roof, yes.
And City Exhibit 9?
Another vantage point, yes.
City Exhibit 10?
Yes.
And then there is notice placed on the doors for City Exhibits 11 and 12. Moving to City Exhibit 13, are you familiar with this notarized letter from the church?
I am.
And did you have specifically the letter is addressed to you. Did you have conversations with members of the church prior to issuance of this letter?
I had conversations with Ms. Taylor, who is the appellant or the representative for the church, via phone and via email prior to receiving this email with the notarized letter authorizing the department to do the demolition of the property.
Were there any conversations regarding the cost of the demolition or fees associated with that work?
I did. At the time when I spoke to Ms. Taylor, I explained the city's process for the bid for placing a property out to bid for demolition. I explained that the city will have our demolition contractors who are part of the master demolition program go out to the location. They will survey the location and provide a price to the city for the demolition of the property. The city would procure that contract, or under the procured contract would accept those bids and would issue the award the bid to the lowest bidder. Ms. Taylor or the congregation would receive a invoice for the demolition plus a 21% administrative fee. I did advise Ms. Taylor that once they received those invoices for the work that was rendered, they did have the ability to appeal it, to either come into a payment arrangement or have the bill adjusted if they did not agree with the cost.
Was there any request at that time or conversation where the city agreed in any way to abate the administrative fee?
No.
Okay. Moving to City Exhibit 14, is this the bid sign-in sheet?
It is.
Can you tell us how is it that a contractor is qualified in order to be part of the bid process?
Every year, the master demolition program or contract is available for review on the procurement website of the city. The various demolition contractors that are either part of this program or would like to apply for this program will apply to the procurement department, and then they will go through the process of being authorized to join the program. In this case, there are 11 contractors that were approved to bid on this day. A email was sent out and notification that on February 27th, 2024, this property was being placed out to bid for demolition. At that time, 6 contractors attended the bid process, and potentially we could have received 6 bids for the demolition of this property.
Moving to the next page, 2, 3, 4, 5, 6. I believe this is this the result of the 6 bids that the city received? Or
Yes.
the-
All right, so Ms. Reinhardt, can you enlarge that? It's difficult to see.
Yes, please let me know where I should scroll in order to make it more visible. I will note, though, that the property address is at the far left side in order to make sure that this is, in fact, the correct property.
So this document illustrates the bids that were received for the demolition of the property. They range from $48,888 from Pedro Demolition or Pedro Construction Incorporated, all the way through to the last bid that we received, and that 6th bid was from A&M Curran for $138,000 for the demolition of the property in its entirety. We awarded it to the lowest bidder, which was Pedro Palmer. There is no breakdown of the associated costs for the demolition, as this is a quote. The contractor takes it upon themselves for however much they are going to spend on this demolition.
Would obviously, these bids are placed before the work is actually performed. If the cost of the work goes up when the work is actually performed, does the cost that the contractors are paid go up?
No, so if there is additional work that is required in association to the demolition being performed in the interest of public safety, and that work is approved for various types of issues that go on, there may be additional costs that are associated with additional work, invoices being sent out to the owner. In this case, there was no additional cost associated with the demolition, and another invoice was not sent, other than being that this is a commercial property. The requirement is they have to have an asbestos monitor on location.
Now, my understanding is we're pausing the conversation for the asbestos monitoring and maintenance work, but I invite the board to correct me if you would prefer to hear some of that information now as well. Okay. I am going to zoom out, but please let me know if you would like a closer look at all of this. And just to clarify the testimony that you just provided, you essentially said that the contractor takes on the risk that their costs may be higher than the bid that they ultimately provide to the city. Was that correct?
So simply put, A&M Curran felt that the demolition of this property would have cost them, and they could do this efficiently, for $138,000. The lowest bid was Pedro Palmer, and his company could perform the demolition for $48,888,000. We accepted their bid, and they assumed the responsibility for whatever those costs are.
Moving to the next page, can you tell us what City Exhibit 16 is?
This is a document provided to the department from the procurement office, basically authorizing the work and authorizing that a demolition has been awarded to the contractor, Pedro Palmer Construction, for $48,888.
Is the scope of the work provided in approximately the middle of the page?
It is the additional work is no sidewalk. Sometimes the sidewalk will be in a state of disrepair, and we will put in for the spec that the sidewalk would be replaced. In this case, the sidewalk was in good condition, and we did not spec that the sidewalk would be replaced. We did spec that the stucco, being that the demolition of these two properties or this property in its entirety would expose the properties at 4144 Aspen and 4148 Lancaster Avenue. Under that requirement, the exposed wall that would be opened would have to be made weather tight, and that is by way of stuccoing that property. Also, there was a 6-foot chain link fence installed across the front of the property, and then they installed an erosion mat with topsoil. Any breaches in the wall between the existing building that was going to stay on location, that needed to be sealed and basically sealed and made weather tight.
Mr. Rabowski, I don't know if you know this. Do you know about how big this building is?
I don't have the actual square foot in front of me. I could go onto Atlas, but I don't have.
Okay, that's
in
fine,
front.
thank you.
If it would help, I could go back to the photographs at the top if you wanted to get a sense.
No, that's fine.
Okay. Moving to City 17, this is a notice of demolition permit. Does this reflect all of the information previously provided, indicating that the city obtained a demolition permit to in fact do the work?
The city did issue a demolition permit per the state requirement. It does list the amount of the demolition cost at $48,888.
With the scope of work they described at the bottom as well.
It's pretty much written exactly as you saw it on the bid paperwork.
I am skipping a couple pages here because this pertains to asbestos. Moving to City Exhibit 24, this is a certificate of approval. Inspector, can you tell us what this indicates?
At the completion of a permit or a demolition, the system will generate a certificate of approval, which goes out to the permit holder or goes out to any representative, saying that your permit is closed and it's been approved.
That the work has been completed according to the scope.
Yes.
Now the next page, I am zooming out so that you can adequately view it. Please let me know if I should change that perspective at all. This is a photograph. Can you tell us what we're looking at here?
This is the finished demolition site at 4130 through 42 Aspen Street.
You know, could you zoom out a little more, Ms. Reinhardt?
Yes.
Okay.
There is a second photograph as well in order to get perspective. I'm going to turn to that now, but can return to this if it helps clarify. This may also provide some information regarding the previous size of the.
Regarding what?
The previous size of the building.
Oh,
Because
okay. I'm sorry. Your words went together and I didn't quite catch it. Thank you.
I apologize.
To answer the board's chair question, the lot size is 8,862 square feet, and then the improvement area is 4,050 square feet.
Thank you. That's very helpful.
Would you like me to move to the previous photograph in order to judge the size of the lot again, or change perspective for these photographs?
Anybody on the board need to see the photographs again?
No, I'm good.
No,
We're good.
Thank you. The next several pages pertain to the asbestos, so I'm going to skip those for now. Moving to city page 40, this is an abatement work invoice. Does this reflect the amount in labor, materials, and equipment that was charged to the city of Philadelphia?
This actually, yes and no. This shows the labor that the city paid, which is that $48,000 invoice. And then it also shows the administrative charge, which is the 21%, bringing the total $59,154.48.
Just to clarify, the labor, materials, and equipment number, that is the amount that the city actually paid for the work that was completed?
We accepted a bid of $48,888 and we paid $48,888.
I have no further questions at this time, but request the possibility of recalling Inspector Rabikowski on rebuttal.
Any other witness or evidence you want to put on right now?
Not at this time.
Okay, so Ms. Taylor, you've heard what the city has provided. Do you have any questions for Mr. Rabikowski that have not already been answered?
Yes, I do. Again, as I was speaking earlier in reference to the lack of itemized bids, I think I understand the process, and I appreciate Mr. Rabikowski did give me a great explanation of things when we met. I did not anticipate that we would not have an itemization of the cost, and I'm not going to belabor that. But I think it's very important from a point of transparency and also in helping someone if they have a question. And we do have a question about the demolition. Now, I understand.
What is your question?
The question is that the property located at 4148 Lancaster Avenue, that wall was stucco and we're being charged for it, and that looks like it was an expensive job. I do not have information to have me feel convinced that we did that kind of damage to their wall. From everything we knew, we had not harmed their wall at all. So if Mr. Rabikowski can explain to me why that was included, that would be very much appreciated.
Mr. Rabikowski?
So anytime the department does a demolition where a building is connected to an adjoining property and a wall is exposed, the department will apply a weather-tight material commonly known as stucco under the master demolition program.
However, Mr. Rabikowski, that building 4148 is not adjoined to ours. It never has been. It's always been separate. That's why it's a concern. I do understand about when you have the party walls or adjoining walls that yes, you would need to do something, but that was never joined. There was always a space between theirs and ours, probably about almost 2 feet.
If it's connected and we have so I don't have the prior notification. All I can go is that on the spec that was written on the permit, and the spec called for the stuccoing of the 2 adjoining properties.
I know you, forgive me, I'm just trying to make sure I'm understanding. I understand you're saying that you don't know how that occurred, but.
Okay, we understand your point, that what you're saying is that your building was not attached.
That's correct, and that's very, and that's why then we look and say, why are we paying for that? What's the amount we paying for that?
Okay, and Mr.
I don't distrust you, Mr. Rabikowski, I'm just saying,
Okay.
I didn't understand it.
Can you confirm that that wall was in fact waterproofed or stuccoed as part of this process?
It's in the invoice. Okay,
I'm asking Mr. Rabikowski.
I'm sorry, forgive me.
That's okay.
So I'm just looking at a portion of a city record to see if I can provide you a little bit more information.
Madam Chair, may I speak about that?
Just a minute, let's see if Mr.
I'm
Rabikowski.
sorry, that's what he thinks.
Okay.
So if you forgive me, if I could share my screen
Yes,
or ask Ms. Reinhardt to bring up the city atlas street view of the property in question, but I actually have it up in the system. I could show the screen to the board.
why don't you do that?
Okay. Can everybody see my screen?
Not yet.
Yeah. No,
How about now?
It's scrolling. It hasn't come up.
oh, there we go. Got
Now
it.
it's coming.
Good old city network. Sorry about that. So this is from the city's Atlas website.
Mhm.
This shows the property at 4130 Aspen. This is the property on Aspen 3144. So I have a street view from my vantage point. It looks like it's connected. So that wall would be exposed when we did the demolition per the requirement. This wall would have to be stuccoed, or at least a weather pipe material in our with our spec. We asked for it to be stuccoed. And moving down the line, this is the property on Lancaster Avenue,
Can you scroll
41,
down,
40.
Mr. Rubikowski? Can you like scroll? Yeah, that's better.
So this is the property at 4148 Lancaster Avenue, and this is the property on Aspen, 4130 through 42 Aspen. It looks and appears to be connected to the adjoining property. So when we did the demolition, it would have exposed that side wall. And in the previous photo that Ms. Reinhardt showed, it did show new stucco applied to both those sides.
You're on mute, Paula. We can't hear you.
Sorry about that. All right, Ms. Taylor, did you have any other questions for Mr. Rubikowski or Ms. Reinhardt?
Well, no, respectfully, there was a separation between that. I think that photo is, I'm not saying you admit.
Okay, well, you would have to show us because the city is showing us what they're using. You would have to show us.
We had windows on our side. We could open our windows at the side and open up, and you have space.
But okay, but we would have to see evidence of that. We would have to see something. I don't know if you have photos of the building before it was demolished or when it was in use. Were you still using it at a time that it was in this condition?
We were using the educational building primarily at that point.
I'm sorry, is it what?
We had a building next to it, 4144 Aspen. We were using that. We were using that building primarily at that point in time. Because
Okay.
we had a problem with the roofing, so we weren't going in and we were trying not to cause any more problems with that.
Okay. Ms. Reinhardt, did you have anything else you wanted to present?
Not at this time.
Okay. Ms. Taylor, do you have anything else you wanted to?
I'd like to ask, is it possible for me to see if I can locate something that can show you if there was separation there? And respectfully, I don't know a lot about this, Mr. Rubikowski, but are there any, not other than just pictures, maybe plaques that show where the buildings are placed that you might have access to? They're not challenging because I really know.
Ms. Taylor, it's really up to you.
Okay, that's fine. I was just asking a question, Madam Chair.
Okay. And you would need to provide us with information. In addition, for you to challenge the bill at this point, we would need something from you if you're challenging. The city does not have any itemization. They have the bidding that they took. They have the process that they use. They get one overall number, and that is all there is, as you have learned. So unless you're going to be able to provide us with some other information as to why this bill may have been unreasonable and what it should have been or could have been or might have been, there really isn't a way for us to parse it out. So I think that's where we are. So does the board want to go back and have a conversation about this?
Yes.
Yes.
Yes, please.
Okay, everybody just stay where you are.
Have everybody back. Tax Review Board is now in session. Yes. All right. So the board did have a brief discussion of the evidence produced, the arguments made, the circumstances that are surrounding issue, and we are issuing the same decision for each bill. And that is for each of the two bills in question, we are abating the interest and we are abating 1/2 of the administrative charge. We recognize, Ms. Taylor, that an itemized bill might make you understand a little better or feel a little better with your fellow board members, the circumstances. However, the city's process did follow the rules and regulations and ordinances that they're required to follow. The lowest responsible bidder, and a significant amount of work was performed. Can I get concurrence from fellow board members?
Yes, John O'Connor, I concur.
Nancy Camerdiner, I concur.
George Matthews, concur.
Paula White, I concur. Mrs. Taylor, you'll get a letter from the Tax Review Board in about 2 weeks with that decision, with all of the information.
It's okay, I just.
Okay.
Is that all right?
Yeah, I don't know what happened. Okay,
It's okay. Well, I just want to thank each of you for the time you spent and the consideration you gave, as well as the law department and Mr. Robert Kowski. Thank you very much.
You're welcome. Good luck.
Thank you again.
All right, we are gonna move on. Case number 3.
yes, they're gonna be in the room in a second.
All right. Case number 3, which is 2866 Welsh Road, last 4 digits of the docket, 9631.
Have a seat, keep your voice nice and loud, okay? Thank you, thank you.
Hey, good afternoon. Yeah, you're good. Okay, so we can see you all. My name is Paula Weiss, Chair of the Tax Review Board. Welcome. Could each of you please identify yourselves? Full name, please.
George Thomas.
I'm Cecily George.
Jimmy George.
Okay. Do each of you?
I'm sorry, I didn't get the second and third person's names. They
Okay,
might spell them for me.
Cecily George. CICILY. George is the last name, George.
Okay, Ms. George, and sir, your name?
Jimmy George.
Okay.
Ask if you can speak into the microphone. Or if you know where the microphone is, it will help all of us.
Okay.
Okay. And do each of you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes.
Thank you. All right, we're going to turn to the city representatives to start in order to get the dates in question and amounts in controversy. And then we will come back to you and you'll be able to tell this board what it is, why you're here, what you're looking for from us. Okay?
Okay.
All right, Ms. Reinhardt.
Ms. Mitchell is here in order to read it in. Unfortunately, the city's witness is unavailable for this. I just put in a very late request because I was unaware of it until after the hearing started. If you would prefer me to proceed without a witness, I can do that as well.
Well, they've been here and they've been waiting, so let's see how far we can get.
I understand. Thank you.
Ms. Mitchell?
Okay. 2866 Welsh Road. This is for a license fee. Bill date 6/27/2023. Bill number 6770721. Principal amount, which is the current license fee, which is $63. Past license fee is $627 even. Interest is $259.13. Penalty fee is $518.26 for a total of $1,467.39.
Can you say that penalty fee again?
Penalty fee is $518.26.
Thank you.
You're welcome.
All right. Ms. Reinhardt, any opening comments?
Thank you. Yes, I would just like to say that the city does not have documentation of any exemptions for the rental licenses for the years in question. Petitioners had a rental license and paid on it beginning in approximately 2003 for several years. And then my understanding based on the petition is that petitioner's son moved into the property And therefore, they believe that they are qualified for an exemption for fees during that time. However, under city code, the department is authorized to request documentation of this exception, indicating just simply that confirmation that petitioners would in fact qualify during that time. The city has been unable to locate any such either documentation, notes indicating that there were conversations to such, and the city has not received a response pursuant to a request for said documentation. So respectfully, at this time, as the bills accumulate each year and are due, in this case, in approximately, I believe, January of each year, the fees in total and the subsequent penalties that go along with them would have been charged before petitioners appeal rights. I apologize if I could say that just a little bit more clearly.
You're saying they filed too late?
They filed too late in each case. As appeals are due within 60 days of the mailing and accrual of each fee, it's the city's position that as the fees accumulated each year and the penalties came up on each of them, that this petition for a number of years in total was too late in July of 2023. As
What's the years involved?
I believe it was 2011 through 2023.
Okay, got it. All right. Do you know that bills went out?
I cannot have someone testify to that today.
Okay, Ms. Mitchell can't see that?
Only we cannot, as we know that everything is online, and they will get a notice online.
I
From
can also,
2011?
Mr. Higgins is also available to testify as a custodian of record. And he can provide some information regarding this is license fee number 233078.
All right, why don't we start with the petitioner and then we'll come back and see. Mr. Higgins, you'll have to turn your camera on if you're gonna testify. All right, go back. Mr. Thomas, could you tell us why you're here today?
Because of the penalty and the license fee. My son and family was living there until 2023.
Okay, so
That's
do
why
you
I
have
did
do they have any documents to show they were living there? Utility bills or driver's license or,
driver's license here.
pardon me?
Driver's license.
Okay, hang on, someone's gonna come. Mr. George, are you the party, one of the people who was living in the property?
Yes.
When did you move in?
My wife moved in June 2010, and I moved in after we got married in July 2010.
And when did you move out?
In 2023 of,
Okay.
I think it was in June or July 2023.
I would like to say that I have about 5 driver's licenses in my hand. Two are for Mr. Jimmy George, who is right here. And then the other person is Larissa Anita George. She's holding a marriage certificate that says that they were in fact married on July 10th. Yeah.
Okay,
No, in July 2010, the 31st day of
which is what he said.
And then in my other hand is, again, driver's license for Larissa Anita George. They've all of these driver's licenses have the address 2866 Welsh Road.
Okay, could you make a copy of one or some of them for the file?
I'm gonna do a 5 phone.
Okay, so, all right, so, and we can provide that to Ms. Reinhardt as well. Okay, so was this a rental property before 2010?
Yes,
Okay, and do you now, Mr. George, you don't live there anymore?
Correct.
You both moved out?
Yeah.
And is the intent to rent it again?
yes.
Is that how this came up? Got it. All right. So we can, Ms. Reinhardt, if we can provide you with their documentation that in fact family members lived there over these last number of years, does that help?
So, the city typically requires an affidavit, indicating that family members live there for each year. I would have to talk to, would I be able to talk briefly to Mr. Higgins? In order to,
Well, the board can actually, we can act. I mean, that's okay. I'm just saying that we're going to provide you with their documentation. Board members, are there any other questions?
No.
Do you
No.
want to have a brief conversation?
Yes.
Yes. All right, we're going to step back.
could I put one thing on the record?
Surely.
The city does not have any documentation of these types of affidavits that are required in order to waive these fees. Could I ask the petitioners whether they provided any of these affidavits to the city over the years?
Say that again?
Have you provided any affidavits to the city over the years indicating that it was a family member who lived in this property?
No, no.
How would they have known to do that?
It is part of the rental process. And there are people who regularly rent properties who do, in fact, switch it over in order to ensure that they do not continue to hold a rental license.
We were not renting it, they were living there, it's our children.
I apologize, I could not hear that.
I think she
They were
said.
renting it, they were living
living
there
there.
because, they are our kids.
Did you get any bills during these years, Mr. George, asking about renewing the rental license?
Me? No,
Yeah, to the property, or Mr. Thomas, did you get any bills?
no.
Or, okay,
When I went to the license, that's why, then only I know that there is a penalty, interest, and a license fee.
okay.
Do you?
Go ahead, Ms. Reiner.
I just have one final question. Did you notify the city in any way at the time that your family members moved into the property, or have any kind of conversation about the rental license?
We don't recall.
No.
Just so the record's clear, I see you shaking your head but did not hear a verbal response. I apologize, that might be the microphone. You said no?
No.
Okay, I have no further questions.
Okay. All right, we're going to step back.
Okay.
Thank you, Mr.
Everybody,
Higgins.
stay where you are. Please don't touch anything. Just stay where you are.
Okay.
The last lady did.
We've done this at home? From home? No.
Paula, everyone is back.
All right, the tax review board is back in session. Mr. Thomas, Mr. and Mrs. George, Melissa, Michelle, we have looked at all of the information, the documentation and testimony provided by the petitioners today and the requirements. And it's the decision of the tax review board that for the years 2011 to 2023, the outstanding license fee, principal, interest, penalty charges will all be waived and abated. Can I get concurrence from fellow board members?
Yes, John O'Connor, I concur.
Nancy Camerdiner, I concur.
George Matthews, I concur.
Paula Weiss, I concur. You will get a letter from the tax review board in about 2 weeks with that decision. The bill goes all that back. Bill will be abated and waived, and at that point, you should be able to secure the 2024 rental license that you need.
Okay, thank you.
Okay, thank you very much for coming in, and good luck.
Thank you so much.
Thank you so much.
Case,
And we're gonna move on.
nope, case 1 and 5 are here in the office.
Okay.
What's going on today? 1 and 5, my God, it's already 3:15.
Well, we were 4 and 6 before, so, you know, we're leveling it out.
All right, so what are we doing? So which case is next?
I think it's Adams Avenue.
Yes, it is Araceli.
We're gonna go back to number 1. Okay. It's
No,
actually 1 and
1
5.
and 5.
1 and 5.
1 and 5, yeah. Come on. Just have a seat.
Good afternoon.
Afternoon.
My name is Paula Weiss, Chair of the Tax Review Board. And your name is,
Aracelis Caceres.
and do you swear or affirm the testimony you're about to give will be the truth?
Yeah, I swear.
Okay, thank you. So we're moving on to cases 1 and 5. Last 4 digits of the docket, 8984 and 8985 for 4270 Adams Avenue. So Ms. Caceres, we're going to start with the city representative who's going to provide us with the dollar amounts in controversy and the dates involved, and then we'll come back to you and you can explain to our board why you're here and what you're looking for. Okay, Ms.
Okay.
Reinhardt?
I am going to ask Ms. Mitchell to read in the information.
Okay, 4272 Adams Avenue. This is a CSU case. Bill date 1/17/2020. Bill number 2689683. Principal amount $7,675 even. Admin charge $1,611.75. Interest $1,671.48 for a total of $10,958.23. Second entry, 4270 Adams Avenue. This is also a CSU site improvement case. Bill date 1/17/2020. Bill number 2689665. Principal amount $5,275 even. Admin charge $1,107.75. Interest is $1,120.68 for a total of $6,099.56.
Okay, Ms. Reinhardt, any opening comments?
Yes, as an initial matter, both of these bills were sent to the prior owner. And it was not Ms. Caceres who received these bills. And I see her shaking her head just in order to, not at all. I just wanted to note it for the record as well. If you would like, I can share my screen in order to show you the bills themselves. But as an initial matter, it is the city's position that as these bills were not issued to Ms. Caceres, that she is not personally liable for these bills. And as a result, the tax review board does not have jurisdiction over bills that have been appealed that were issued to other people.
And who were these bills issued to?
These were issued to Alexander Kershentsev and Vladimir Kershentsev. I can spell those if it would be helpful for the record.
Were they the owners at the time?
They
That's
were
what we
the
get into.
owners at the time that the work was completed.
Okay, and have these bills been liened against this property?
My understanding is that they have not. However, any liens would be, this would not be the jurisdiction in order to challenge any liens on the property. That would be through a serie phasia proceeding in the Court of Common Pleas.
Right, not to interrupt, I'm trying to figure out why Ms. Caceres is here. Ms. Caceres, why don't you explain to us why you're here, what you have to do with these bills?
Yeah, well, by the time.
Can you speak into the microphone, please?
The microphone is the black box on the table. Can you just move up a little bit closer to that?
Oh, should I hold it? This is, okay, where should I go?
Let's move a little closer.
Okay, yeah, well,
Thank you.
by the time that the fire happened, it wasn't my property, it wasn't under my name. So fire happened in 2019 in May, and the bill was sent on January, the next month. I mean, I wasn't the owner. I bought the property after the fire.
Do you own the property now?
Yes, I do.
Okay. So it sounds like, though, what the city is saying is they're not looking to you to pay these bills.
But it's under my name.
Is it? The property is under your name.
Yes, exactly. And
Right,
the
but the
lien-
bills,
Mhm.
did you get a bill in your name?
Yeah, that's what I'm saying.
You have it with you?
Mm. I think I have it here. Because I requested it, but it's-
In the bill?
Let me see, because Grace, if I can. I have one check with you here.
This bill is not your name though. That's that's the prior owner.
No, I'm actually looking at the bills that were attached to the petition. They're not.
They're in the Kershaw's name. I think what she's saying is that it's on her account
In my
somewhere.
account, yes.
Yeah,
that's
like
what I
when she
mean.
goes to,
To the system, in the
Exactly.
real estate taxes and everything.
There
It
you
shows, then I have a lien holder in that account, and under my name, because the name of the property is under my name. So
Okay,
I know
got
how
it.
to solve that situation, yeah, exactly.
Okay, so the bills are not in your name. They're still billing the prior owner. I assume these are the people you bought the property from,
Mhm.
correct?
Yes,
Yes. So Ms. Reiner, you're not billing Ms. Caceres, you're billing the prior owners, and that's going to continue, correct?
That is my understanding, and I can show the board the copies of the bills that we have in order to confirm that as well, if you would like.
That would be fine. And then this property is not, these bills are not yet liens on the property?
Not that I was able to search. I did run that search over the last few days a couple times in order to make sure that I was not either typing names in incorrectly or did not overlook anything. But not, I can provide, not that I'm aware of, and I did make an attempt in order to try to confirm that.
So, Ms. Caceres, have these bills impeded you from doing something with the property that you want to do?
they send me like notices saying that they're gonna, take property away from me or, bank account in case I don't pay this amount.
In your name, or just that it's come to the property?
The property name.
Okay, so that they're not looking for you.
No, but when I search in the real estate taxes to pay, it shows that I still have the debt in there.
like in the bill. You
It shows
understand?
up in the L and
Yeah,
I.
yeah, if you look at it like, let me pay this property taxes, and shows the like this is like two different amounts, and says like I have the lien, and then I have a debt with the city. That's why my confusion.
So Ms. Reinhardt, if you're saying it hasn't been leaned, but it's still already showing up on her account, the real estate listing,
If-
what is her, where is her?
It's coming up as an
appeal
agency receivable.
process?
That's
Right,
what.
so where is her appeal process?
I'm sorry, through, if it's an agency receivable, but it is under someone else's name, then it would be under that person, because we can still collect from that person in REM or persons in this situation.
Right, but it's attached to her property.
It is for, work that was done though prior to,
Her acquisition?
and my understanding, based on what I'm able to view, is that it doesn't show any kind of names on that search. So there's no information indicating that there's anything that is coming to Ms. Caceres in order to try to get this
I have a
amount.
question, Ms. Reinhardt. We just had a case with a rental license. If in fact, Ms. Caceres decided to rent out her property, which she's well within her right to do, and she goes down to Municipal Services Building and they pull up her account and they see that there is an agency receivable unpaid attached to the property, because they're not looking her up, they're looking up the property. And there's this amount there that's not hers. We just told her it's not hers.
Let me prove it.
What is she supposed to do in terms of, and it's not liened either, right? It's not liened. So when she purchased the property, there was no indication that this was outstanding. So what is she supposed to do as someone who owns this property and as someone who may want to rent it out, may want to do, I don't know, anything? And this is coming up on her property. What is she supposed to do?
So my understanding is that she would be able to provide information at that time that this is not her bill. It is not, my understanding, attached to the property itself. It is simply searchable because this was for work that was done in relation to the property. So this is just simply an indicator saying that this bill against these individuals is due as a result of the site work that was done following a pretty substantial fire.
But we all know
Yeah, but that's the
that
thing,
what
it's
you're
attached
saying-
to that, it's attached to the property, because whenever you see, what is the name, PO, the identifier property, like PO something, then whenever you look for that number, it shows up that. So it's attached to my name too. So I just want to clear that up. Some paper that said I'm not, entitled to that debt, and I want to clear out all the property number with that debt. I want that to be removed.
So how does she do that, Ms. Reinhardt?
Again, it's the city's position that these bills are attached to the people that are involved here and not to the property themselves. So she would be able to provide copies of the bill if she would like to. At that time, if anyone would, have any concerns based on how that shows up. However, these are legitimate bills that go to Alexander Kershentsev and Vladimir Kershentsev that were adequately and properly noticed. And there's.
We understand that. We understand all of that, but you need to understand as well that for her, as the new owner of this property, this is an impediment. This could be an impediment to her if she wants to take out a mortgage loan or a rental license or do any number of things with her property, that this unnamed, no name attached, unnamed outstanding debt is attached to the property she now owns.
And
And you're telling us she has no place to appeal this.
And on top of that, what assurances does she have that the city is not gonna lien this outstanding debt to the property?
So
At some point, they will.
there are, I don't believe that they will, because this is for a different person. And
So
this
we've seen it.
was
We've
issued in
seen
2020.
bills that become in rem and in personam all at the same time.
Mhm.
I'm not, Ms. Lauren, I'm not saying that you're what, that you were here at that time, but we've had other attorneys from L&I argue that one bill can be both in personam and in rem all at the same time. We may even have a memo from somebody
That was the
arguing.
water case,
Might
but
be
same issue.
right, it was a water case, but that the city's position from the law department has been, oh no, this one bill can be in rem and in personam. We can lien it and we can go after the person who used to own it all at the same time. And then once it's liened, of course, she would be able to appeal to the Court of Common Pleas if she chose. But she's now in limbo for, and then at some point having to incur some cost perhaps. With at this point, no avenue to, no recourse?
So if I may address that, first of all, I believe that her testimony was that there have not been any issues that have come up to date. There have not been any denials or fees associated with it.
Yes, I went to, and I requested a license to rent, and that's when it came out. I didn't know I had this until I went there. That was in, I think it was, in March of this year that I went there. I came here first. I went there and then I came here because they sent me here. They were sending me from department to department. They didn't send me to the 8th floor, but in order for me to go to the 8th floor, was 8th floor? They said I needed an appointment, and then I came here.
May I ask petitioner a few questions?
Sure. And then the board is gonna, I think, go back and have a conversation.
Okay. So first, just as a very general statement, in order to answer the question that you asked, liens can always be challenged in serie facie filings at the Court of Common Pleas, and that is the proper venue in order to dispute any liens. Turning to Ms. Casera, do you have a mortgage currently extended by the prior owners?
No, no.
I'm sorry, I didn't catch that answer.
No, I don't.
Okay, would you be surprised that there was a mortgage recorded? That you took out $130,000 from the prior owners? Or let me pull this up.
And this is relevant because
it shows a relationship with the prior owners where the current owner is now challenging the bills that are issued to the prior owner in rem, which appears to be a backdoor way to challenge the legality and try to wipe out the city's validly noticed, properly issued site abatements following a pretty serious fire.
Yeah. But I didn't have any mortgage.
I apologize. I did not hear.
I don't have
and she did
mortgage.
not have a mortgage.
No, I don't. That's this information you can look at anywhere. I don't know where I found it.
You didn't borrow money from the prior owner to buy the property?
No. I paid him and different quotes payment because we know them. Well, my brother knows. They friend for.
Sorry, I'm having trouble.
Yeah,
Can
can you come in closer to the mic?
My brother is very close to him, so we were paying and money in cash and like exchanging vehicles and trucks and stuff like that. So that's how we pay them.
All right, do you have anything you want to show us, Ms. Ronhart? Because we would like to step back for a minute.
Yes, if I can show my screen, this is, please let me know if you are unable to see this. This is the mortgage that is recorded for 4272 Adams Avenue. And it indicates.
I'm sorry, you need to zoom in. We can't see this.
Yeah, I can't read any of it, but even when you zoom.
Is this helpful?
Yes, that's great.
Okay, the top indicates that the mortgager is petitioner, and then in parentheses borrower, and that the lenders are Alexander Kershentsev and Vladimir Kershentsev, who were the prior owners, as petitioner testified. I was wrong about the amount, but it is $100,000 that was borrowed and not
Mhm.
$130,000, as
Yeah,
I just.
but I paid him on December of 2019.
Right, it
That
says due and payable in December of 2020.
But I paid in December 2019, so that's not a mortgage, like if you go and borrow from a bank or anything like that.
Okay, so it was paid.
Yeah, it was paid. I don't owe him nothing.
There is no satisfaction filed.
That may be, but it does say due and payable in in 2020.
Yeah, you see, like in between two people, no, and like a.
Well, you should know from what Ms. Saris, what Ms. Reinhardt is saying is it's still showing up on the city records.
Okay, okay.
Does the board want to go back?
Yes,
Well, the question was, if I currently have a mortgage. I don't have any mortgage.
okay, we got it. We're gonna step back. Ms. Caceres, just sit where you are.
Mhm. Mira que no te falta. Te voy a decir rapidísimo. Y a mandar lo más que te puedas. Sí, es muy mal, muy mal. Estoy muy decepcionada. You broke my heart. The way you behave, you never behave like that. But behavior. Si la bebé en Bronte man is gone. Because you like to be your mom, right? You like to go to work your mom. But if you behave like that, I cannot take it to work anymore. Okay? Are we clear? I have my daughter with me today. Because my feelings, because my feelings, because my feelings. I don't understand. I want to cry. Deja esa confesión. Please. Mommy's tired. Mommy wakes up every day at 5 in the morning to get you ready, to get it ready, to get Papa ready. And I have to work hard too. Please. Emma. Everyone's fine? Porque tan alto de ti. Everybody's fine because they don't want to see you around like bothering mommy. They don't want to see a daughter who doesn't respect her mom. They don't want to see somebody bothering to everybody and respect. No, get here, get up and sit there. Very disrespectful. Hmm? What? No, you don't love mommy. You don't love mommy because if you would love mommy, you wouldn't be like that, behaving like that. If you would love mommy, you wouldn't be like that. You would behave well. But guess what? You don't love mommy. You don't love mommy. Because otherwise you wouldn't. You see? Oh, sorry, Melissa.
Back. All right. Ms. Caceres, the board did discuss your circumstance and situation, and we are sorry, but there does not seem to be anything that we can do for you at this time because the bills are not in your name. So that our decision is to deny the petition, but we would suggest that you may need to consult an attorney to handle this with the city, because they do seem to have left you in limbo. So can I get concurrence from my fellow board members?
Yes, John O'Connor, I concur.
Nancy Camerdiner, I concur.
George Matthews, I concur.
Paula Weiss, I concur. You will get a letter from us in 2 weeks that this petition was denied, that we did not take any action on this. Either party may appeal to the Court of Common Pleas. You have 30 days from the date of the letter to determine if you want to file an appeal to the Court of Common Pleas. Otherwise, you're going to need to find some other avenue to try to remedy this for yourself and your family. So thank you for coming in, and I'm sorry that there was nothing that we could really do to address this. And we're gonna move
She
on.
didn't even have the answer, the lady. She didn't even know what she was talking about. Like,
We understand your frustration. We
We
do.
really do.
But the jurisdiction of the board cannot handle a case where the bill is not in your name.
yeah, but it's under my account and under my property.
We understand that, but one of the things in order for the tax review board to hear a case is that the bill is in the person's name. Okay? All right, Paula, next case is number
Yeah,
7.
we're gonna move on to case number 7, which is 6149 Yoakum Street, last 4 digits of the docket, 8556. I believe the petitioner is here on Zoom.
Yes, Mr. Clark?
Mr. Clark, could you turn your camera back on, please?
I
One second.
apologize. I was sent out of the Zoom for a while. Which case is being called right now?
7, which is,
Carter Sales.
thank you, Carter Sale, 6149 Yoakum Street.
Thank you.
Last to the docket, 8556.
Is Ms. Campbell still in the waiting room?
I believe she left.
Okay, I just wanted to make sure that she wasn't waiting for an administrative matter. Thank
No.
you.
Thank you. I appreciate that. All right. Mr. Clark, welcome. Could you state your full name for the record, please?
Michael Clark.
Do you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes, I do.
Thank you. All right, we're going to turn to the city first for the dates and dollars that are in controversy. Then we will come back to you to ask you why you're here and what you're looking for from our board. Ms. Reinhardt?
Thank you. I'm going to ask Ms. Mitchell, who has been previously sworn, to provide this information.
Okay, thank you. 6149 Yoakum Street. This is a clip case, bill date 9/27/2023, bill number 2023-010155. Principal amount $95.62. Admin charge $20.08. Interest $117.44, for a total of $233.14.
Reinhardt, any opening comments?
Just as a comment, this is, as Ms. Mitchell indicated, this is a clip bill. This was a notice of violation for trash and weeds at, a, lot. There is. I apologize, I missed. who
No,
said
go ahead.
something.
Go ahead.
Okay, thank you. For which notice of violation was sent, and after the compliance date, there was the violation remained.
Okay. All right, Mr. Clark, what would you like to tell us?
Yes, first I would like to dispute the interest. I appealed this back almost a year ago. And I was under the impression that all interest would be seized pending an appeal. It took me a whole year to get a case regarding the matter. So I want to dispute the interest.
Okay,
And
we
also,
can certainly handle that.
I want to get the violation dismissed, please.
Okay, what would you like to tell us about why that should be dismissed?
Yes, if I'll be able to share my screen.
Yes.
Okay, you see the first where it says 61. Can you see?
No, I
Can
can't
you
see
make it
that.
bigger?
Is that better?
Bigger. Can you make it bigger?
Can you see that?
Yes.
Okay, 6149 Yoakum, and the address they have is 6149 Yoakum. Now, that's not my address. I mean, that's the address to the property, but it's a vacant lot. So it will be no way possible I'll be able to get any type of mail going to that lot. I just printed this out today. Now, the first initial violation, they sent, I never got anything regarding that address. I never got anything regarding that violation.
Did we lose the sound?
No.
Go ahead.
Okay.
Clark, you're showing us that the, or what you're stating is that you believe that any notice of violation was actually mailed to the property.
Yes, initially, the first violation was, I guess the initial violation where I had basically 30 days to correct the matter was mailed to the vacant lot. That's the discrepancy that I have with that one, because if I would have got it, I would have definitely made sure that I took care of what I needed to take care of. If I want to show some other photos as well.
Yes.
1 second. Here's the email from Department of License and Inspection.
Which we cannot see. That has to be, you need to be able to zoom in on that.
All right, yes, ma'am. Here's the email. I got the abatement letter on 9/27, and I immediately called over to CLIP to find out what was the status on October the 3rd, 2023. He says, Thursday, I'll be out there fine. I don't have to be present. Just take photos and send it. I told him that was heavy dumping. It was not my stuff. It's a bad neighborhood. They like to dump around in. I try my best to keep it clean and keep the grass cut. I contacted license inspections the day I got the abatement bill, and I was able to get that rectified and got the bill cleared. I just want to show another document. Here you can see that it was resolved on October the 5th, 2023 for high weeds. So it was no more violation on the property. Everything was taken care of. I'm just respectfully asking that this matter be dismissed. Even when you look at the photos, it was an old couch and some chairs that somebody put there, and I was taken care of immediately by one of my guys prior to me even knowing that it was a violation. I had to go over there monthly to make sure everything is good to go with the property. But in final, I just want to say 1 second. In final, I just want to say that I was unaware that it was a violation, the initial violation, because they mailed it, recorded in the records. I never received the mail or anything on that aspect. I would like to ask council, what day was it mailed out?
All right, well, they'll get to that.
Okay.
We'll get to that. Okay, anything else you want to show us right now?
1 second. I just want to share the screen again one more time and show you the condition of the lot. This, if you look at it, is timestamp. It's timestamped at 10/4/2023. That's the condition of the lot. I mean, it's I try to clear it as possible, but that's not all my parcel as well. My section is to the far left next to the house.
Respectfully, I do not see a timestamp on this photograph, and I have not
Sure, let me do it
viewed
again.
a copy previously, so I'm not sure if I get to view it. Like, if I would be able to view it differently, if I would be able to see anything.
If you see on the top, it says 10/4/2023.
I do not.
Was it? Okay, let me see
It's
if
the
I
numbers
don't-
on top, Ms. Reinhardt.
Victor,
It's the JPEG numbers, that's the timestamp.
Top
Oh.
left.
Okay, I see what you mean. I am
2023, 10/4.
Right. So as soon as I got that notice, I made sure I came out there and I take vacant lots seriously within the city of Philadelphia. And as soon as I was aware of it, I came and tried to handle it the best way I could. But the first initial violation, I never received anything from them. I just got the bill in the mail. That's what prompted me to call license inspections the same day as soon as I got it.
But you got the bill in the mail.
Yes, ma'am. But I didn't get the violation. They gave me the opportunity to correct the violation. I never
Okay.
got that bill because it was sent to the lot, I'm assuming.
Okay, thank you. All right, we're going to turn to Ms. Reinhardt.
Thank you. I'm going to share my screen with permission from the board. That
Yes.
is. Okay. This is City Exhibits page 1. First of all, I'm going to call Martin Higgins for the City of Philadelphia.
Hey, Mr. Higgins, good afternoon.
Good
Would you state
afternoon.
your full name and position with the city?
Martin Higgins, Code Administrator, Community Life Improvement Program.
Okay, Mr. Higgins, do you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes.
Thank you. Okay, Ms. Reinhardt.
Thank you. Mr. Higgins, can you please, first of all, is this the notice of violation and order to correct that was sent for the violations at 6149 Yoakum Street?
Yes.
And this is dated August 24th, 2023.
That is correct.
Now, we just heard testimony that this was sent to the lot. Can you tell us where this notice was sent?
333 East Lancaster Ave, apartment 118 in Woodwood, Pennsylvania, 19096.
And is that the mailing address provided to the City of Philadelphia as recorded in the Office of Property Assessment? Okay, indicating where a petitioner would like their mail to go.
Yes.
Now, what violations were found on this date?
So the violations that were issued were for high weeds and trash in a lot.
What's the date of the violation? I'm sorry, I missed the date.
This was
August 24th.
August 24th, 2023. What date were the violations ordered to be complied by?
You'll notice that it says that you're to make the necessary repairs by 9/6/2023, September 6th.
And you are reading from approximately the middle of the first page, just for the record?
I'm reading in the third box, bottom line.
Okay. Moving to City Exhibit page 4. This is a photograph. Can you tell us what we're looking at?
So this is the photo of 6149 Yoakum Street where there was furniture. And I believe it says it was taken August 23rd at 8:22 a.m.
Okay. I am going to zoom in because the next photographs are in fact smaller. But did you go back to the property in order to check to see if the conditions, if there were still trash and weeds at the property?
So I personally didn't. I'm just testifying as the custodian of records.
Did someone from CLIP go back in order to verify?
Yes, I believe it might have been Inspector LaPenta.
Did they find trash and weeds at the property?
No, so at the reinspection, it was just noted that the vegetation had grown substantially.
Okay, so the trash remained. Looking at City Exhibit 5, let me know if I should resize it in order to show it better. This is a photograph dated September 26th, 2023. What are we looking at?
So this is a photo that the crew chief would take prior to what we would call the city abatement.
And what do you see in this photograph?
The overgrowth and trash.
Moving to City Exhibit 5, again, please let me know if I should resize anything. This is also dated September 26th, 2023. This one is 2:09 p.m. and the prior was 9:30 a.m.
Yes, so the surveyor would go back and take photos of the work that we had done at the property to show that there was a violative state when we did the work and that there was a remediation of the code violation.
Okay. And in documenting the date that the work was in fact done.
It appears to be September 26th, 2023.
Okay, I am going to move to page 7, but zoom out. Again, please let me know if I should change the perspective for everyone. This is the abatement work invoice for this property. Do you recognize this document?
Yes.
What is it?
So this would be the invoice that's generated after the information is inputted into the Eclipse system to bill the owner of the property for the work that was done by the city.
Okay, and this was to abate the notice of violation that we just viewed from the top.
That is correct. If you go to the second box where it says abatement work, it has said the work described below was performed in accordance with the notice of violation. It gives the case number as well as the issuance date.
Now, petitioner just testified that he had a photograph from October, I believe it was, of the same year. Would that have been after this work was performed?
Yes.
Okay, and just one moment. I'm going to stop sharing my screen in order to not make everyone very dizzy. So, you said that you are here as a records custodian. Have you reviewed all of the records in the, for this particular case?
Yes.
Are all of these records ones that the city would create and save in the ordinary course of its business?
Yes.
And you were able to access it in the ordinary course of your business?
Yes.
Petitioner further indicated that this notice of violation or this case file was subsequently marked complied. Would it be complied after the city does the abatement work?
Yes. And what I think the petitioner is referring to was a case that was issued later in September of the same year.
Okay. I do not have any further questions for Mr. Higgins at this time, but may request to recall him on rebuttal.
Mr. Clark, do you have any questions for Mr. Higgins?
Yes, yes, sir. My question is, you have my address on the abatement paperwork, but on the city's website, it says 6149. Is it possible that it could have been sent to that initial address? Because it's not updated. I mean, I updated my address with the city, but I go to License Inspection's website, it says mailing address with the exhibit I just showed, it says 6149 Yoakum. So I was just curious if that could be an issue or discrepancy.
Chairwoman Weiss, may I be able to share my screen?
Yes, please.
Oh, my goodness. If you can unshare your screen, please.
No,
Please. You have the ability to share only a given screen,
oh, yeah,
not your entire screen.
sorry. So this is, can everyone see this? Do you need me to zoom in?
I think you need to zoom in.
So there's a tab in Eclipse that notes when we receive return mail. As Attorney Reinhardt showed the document with the notice of violation that we sent to you, Mr. Clark,
Yes, sir.
we don't have documentation of receiving return mail.
Okay. I mean, yeah, what I'm saying, can I ask you another question, sir? Was this sent out certified mail? No.
So,
What-
Mr.
I
Clark,
didn't hear what you said.
the city did show the copies of the actual violation notices with, what was the address? An East Lancaster Avenue address. Is that the correct address for you?
Yes, ma'am. But that letter I never received, and I feel if they should have sent it certified if it was a particular bill. But sir, I mean, it could be a problem with the mail. They could have got a return receipt and confirmed that I got it. Like I don't ignore my bills. That's why I'm on here for this particular matter. I like to handle my affairs. So I never got that letter. The second letter I got when I got the bill that's when I responded. So I went out there the next day. I made the proper arrangements. I called and I wanted to rectify the situation. But that even this hearing, only reason I know about this hearing is because the council emailed me about the hearing on the 24th and said that I needed a lawyer. I never got anything in the mail about this or anything like that. I mean, it's been a year. So this is the reason why I'm on a Zoom. And she contacted me today and provided courtesy and told me that I didn't need to have a lawyer for this because it's just I guess a regular tax appeal or something on that aspect. So the issue.
Clarification's sake, you had a hearing on this case already back in May of 2024 here at the Tax Review Board already. You appealed that decision and then you came here. We mailed you a notification and that notice went to 333 East Lancaster Avenue.
Yeah, I don't have any. I have other hearings. I don't have for this particular matter. So I'm not sure if it's a problem with the mail, but that first case notice, I would have definitely responded and took care of what I needed to take care of.
Okay. Any other information, Ms. Reinhardt, that you want to present?
Thank you. I would just say that, first of all, it was not the city's burden to, under code, send anything by certified mail, that the mailbox rule applies here. And that the record shows that the city mailed the notice of violation and the invoice to the same address that Mr. Clark indicates is his proper mailing address.
Yes, I just have a rebuttal to that. I mean, things do get lost in the mail. I mean, things happen with the mail. The mail service has been unpredictable in some particular matters. I understand that you don't need to send it certified, but that's why I didn't take care of it. I pride myself on taking care of my affairs.
Okay, thank you. Board's going to step back.
Yes.
Everybody just stay right where they are. Nancy, are you going in the room? Nancy? What the- I don't know where she is. Paula, everyone is back.
All right. The board did spend a few minutes and discuss the evidence presented, Mr. Clark's testimony, the case that the city put on, recognizing the violation notices, the photos that were presented, and Mr. Clark's testimony as to his work on this property. And it is the decision of the board that we will abate entirely, in its entirety, the interest that has accrued, and leave the remaining actual bill where the city provided the work to that property. So, Mr. Clark, you'll get a letter from the tax review board that all the interest is being waived, and adjusted bill will follow. Either party may appeal to the Court of Common Pleas should they so desire. That information will be in the tax review board decision letter. And can I get concurrence from other board members?
Yes, John O'Connor, I concur.
Nancy Camerdiner, I concur.
George Matthews, second.
Paula Weiss, I concur. Thank you, Mr. Clark. You'll get a letter with our decision in about 2 weeks.
Thank you.
And we're going to move on. We have one remaining case, which is number 2, 613 North 44th Street. I understand that the petitioner is no longer here in our offices. Her attorney also is not here. However, we did have information from Ms. Reinhardt previously that the city has already resolved and abated this bill. Is that correct, Ms. Reinhardt?
It is. Well, it is correct that we have made the request and that is being processed currently. My understanding is that it may take a few days in order to complete in its entirety. If I may also put on the record, I attempted to reach out to the contact information on the petition. There was a phone number. Every time I called, it just rang. And there was no voicemail set up, so I was not able to notify petitioner previously. And that's the reason that you know, she was unaware when she came in. So I just wanted to let everyone know that.
Very well, thank you. We appreciate the effort in trying to reach the petitioner and save her the time and trouble of coming down. That is appreciated. So I'm going to recommend for our board that we mark this as no action needed. And can I get concurrence from board members?
Yes, John O'Connor, I concur.
Nancy Camerdiner, I concur.
George Matthews, seconder.
Paula Weiss, I concur. So this matter will be marked no action needed. And I believe that actually completes a full docket for us today.
Full.
Thank
It is
you.
full today.
Full. It is done. That's what did they say in, oh God, the presidential press conferences? It's a full lid. We're done.
Is that what it is?
Yeah, it's a full
We are
lid.
done.
All right. Thank you, everyone, and have a good
Thanks,
afternoon.
everyone.
Okay.
Tax review